I request all the dignitaries to kindly join us on the dais. A very good morning to all. It is a matter of immense honor and privilege to welcome you all to the Honorable Mr. Justice G.P. Singh 4th Memorial Lecture, being organized by the National Law Institute, University Bhopal, on the theme State, Courts and Citizens. On behalf of the National Law Institute, University Bhopal, I extend a cordial welcome to our distinguished chief guest, honorable judges, esteemed dignitaries on the dais and off the dais, distinguished faculty members, dear students, and all those who have joined us today. Today's lecture commemorates the extraordinary legacy of Honorable Mr. Justice G.P. Singh, an eminent jurist, distinguished judge, and one of the India's foremost legal scholars, whose contribution to constitutional and statutory interpretation continues to illuminate the path of legal scholarship and judicial reasoning. Moving further, every auspicious occasion in our country begins with the invocation of divine blessings through the ceremonial lighting of the lamp. May I now respectfully invite our esteemed dignitaries to come forward for the lighting of the lamp. With the lamp of knowledge lit, we now move forward to extend our warm greetings to dignitaries who grace us with their presence today. I request Professor Dr. S. Suryaprakash, Honorable Vice Chancellor, NLIU Bhopal, to kindly offer a warm welcome to our Chief Guest, Honorable Shri Justice Ujjwal Bhuyan, Judge Supreme Court of India. I once again request our Vice Chancellor, sir, to welcome our esteemed guest of honor, Honorable Shri Justice Vishal Dagat, Judge High Court of Madhya Pradesh. I now invite Professor Dr. Ghayur Alam, Senior Professor, NLIU Bhopal, to welcome our esteemed Vice Chancellor, Professor Dr. S. Suryaprakash. Next, I request Professor Dr. Birpal Singh to kindly welcome Professor Dr. Ghayur Alam. Moving further, as a mark of our profound respect and heartfelt appreciation, we shall now extend a token of welcome to our esteemed dignitaries seated off the dais. To begin with, I respectfully invite Professor Dr. Sanjay Yadav, Dean Postgraduate Studies, NLIU Bhopal, to extend a warm welcome to Shri Justice Purshendra Kaurav, Judge High Court of Delhi. I now request Professor Dr. Atul Kumar Pandey, Dean Undergraduate Studies, NLIU Bhopal, to welcome Honorable Shri Justice Rajendra Menon, Chairperson, Armed Forces Tribunal, New Delhi. जीत सिंह को बख्शी सर से I now request Mr. Vivek Bakshi, Registrar NLIU Bhopal, to welcome uh, Honorable Shri Justice Ajit Singh, former Justice, High Court of Assam. I again request Mr. Vivek Bakshi, Registrar NLIU, Bhopal, to welcome Honorable Shri Justice Shantanu Kemkar, former Judge, High Court of Madhya Pradesh. Next, I invite Professor Dr. Uday Pratap Singh, Chief Warden NLIU Bhopal, to extend a warm welcome to Honorable Shri Justice Saten Singh, Judge Lok Ayukt Madhya Pradesh. Having concluded the ceremonial proceedings, we now turn to the next segment of today's event. It is my privilege and honor to invite Professor Dr. S. Suryaprakash, Honorable Vice Chancellor, National Law Institute, University Bhopal, to deliver the welcome address.
Honorable Justice Ujjal Bhuyan, Judge Supreme Court of India, Honorable Justice Vishal Dagaji, Judge High Court of Madhya Pradesh, and Member General Council NLI Bhopal, Honorable Justice Pushendra Kauroji, Judge High Court of Delhi, Honorable Justice Rajendra Menon, Chairman, Arms Tribunal, Delhi, Honorable Justice Ajit Singh, former Chief Justice, High Court of Assam, Honorable Justice Shantanu Kemkar, former Judge, High Court of Madhya Pradesh, and Shri Satyendra Singh Ji, Lokayukta, State of Madhya Pradesh, Shri Narendra Pratap Singh Ji, Deputy Lokayukta, Shri Manoj Srivastav, Principal Judge, Principal District and Sessions Judge, distinguished members of the bench and bar, esteemed members of the faculty, respected guests, dear scholars, students, ladies and gentlemen. A very good morning to all. Okay. It's my privilege and profound honor to welcome you to Justice G.P. Singh Memorial Lecture, a distinguished academic tradition that celebrates the life, scholarship, and jurisprudential legacy of one of the India's most revered jurists. This occasion is not merely a commemorative event. It is an intellectual pilgrimage, a moment where we gather to reflect upon ideas to continue to illuminate the path of justice in our constitutional democracy. We are deeply privileged to have with us Honorable Justice Ujjal Bhuyanji, Judge, Supreme Court of India, as Chief Guest, and commemorative lecturer, Justice Bhuyan's distinguished career marked by constitutional fidelity, judicial restraint, intellectual depth, and an unwavering commitment to justice makes him an exceptional fitting choice, Honorable Justice Ujjal Bhuyan, to deliver this memorial lecture dedicated to Justice G.P. Singh. Ladies and gentlemen, it is irresistible impulse being from the academic community. When this is an academic event, I have to say a few words about interpretation, about Justice Ujjal Bhuyanji, and also Justice G.P. Singh, and in general about interpretation. So, law is often described as architecture of civilized society. Yes, statutes, however, carefully drafted are but carefully arranged words on paper. Statutes are carefully arranged words on paper. They acquire life, purpose, and authority only through interpretation. If legislation is the body of the law, interpretation is the soul. The soul of law is its interpretation. It breathes meaning into language, resolves ambiguity, harmonizes competing provisions in law, and ensures that justice remains the ultimate destiny of every legal journey. Interpretation, therefore, is not an exercise in linguistic gymnastics. It is the disciplined and principled process through which courts ascertain the meaning of the legislative text in light of purpose, context, history, and constitutional values. Judges do not rewrite statutes, they reveal the meaning embedded within them. They ensure that while words remain faithful to the will of the parliament, that is, legislature, they also remain consistent with the spirit of the constitution. Few scholars have shaped this field profoundly of Justice G.P. Singh. So for generations of judges, advocates, academicians, and students, his monumental treatise, that is, Principles of Statutory Interpretations, has been more than a textbook. It has been a trusted companion in search for legal meaning, affectionately known as in the courtrooms as simply as G.P. Singh. The work has become an indispensable guide to understanding the canons of statutory interpretation and construction of the words and phrases in the statutes. It has taught us that interpretation is not mechanical literalism, nor is it judicial legislation. It is disciplined endeavor. That is, interpretation of a statute is an disciplined endeavor to discover the meaning of the law while preserving legislative intent and the constitutional morality. Because every statute should work under the umbrella of the Constitution, constitutional values, and constitutional morality. Coming back to Justice G.P. Singh demonstrated that statutory interpretation is both a science and an art. It demands precision, that is, interpretation demands precision without rigidity, creativity without arbitrariness, and fidelity without formalism. His scholarship reminds us that words cannot be divorced from context, nor can statutes be isolated from the constitutional framework within which they operate. Because under the Constitution, all statutes, all interpretations, and every judgment pronounced, it should be compatible with the constitutional principles and the goals. So the philosophy assumes even greater significance in our own times. Contemporary legislation increasingly under complex questions involving technology, national security, environmental protection, financial regulation, and human rights. Courts are therefore called upon not merely to read statutes, but to interpret them in a manner that advances justice while preserving constitutional values. The task of interpretation has never been more challenging nor more consequential than in present times. So, my friends, what is the minute things that would be looked into in the statutes, whether it is the words, phrases, punctuation, comma, full stop, noun, preposition, and even the verbs. Here, it reminds me one case decided by the High Court of Andhra Pradesh. Sir, I will take 2 more minutes. So, this is a wonderful case in the context that in 2014, the Andhra Pradesh, state of Andhra Pradesh was divided, and a statute was passed, AP Reorganization Act. And the residuary state of Andhra Pradesh and the new state Telangana were formed. And one of the provisions of the statute says that the residuary state of Andhra Pradesh should have a capital, and the central government should give financial assistance for the construction of new capital, the governor's house, assembly, high court, etc., what are the buildings that are required for a new capital. So the central government should give financial assistance. So the first government for the new state, Chandrababu Naidu government came, and they acquired land 33,000 crore. So sorry, 33,000 acres of land from the farmers in Amravati, and they decided to establish capital Amravati at that place and declared that Amravati should be the capital of Andhra Pradesh. And in the next turn, there is change in the government. YSRCP government has come. Jagmohan Reddy, he became the chief minister, and he decided that instead of one capital, let there be 3 capitals, because there are 3 regions. So the legislative capital in Amravati, judicial capital in Kurnool, and administrative capital in Visakhapatnam. So the aspirations of 3 people of 3 regions may be satisfied. The farmers who gave 32,000 acres of land under the land pooling system, Government didn't pay them any compensation. There was a scheme under land pooling. So they challenged the legislation of three capitals in the state of Andhra Pradesh. So the arguments, they went on for several days, months, and the most brilliant lawyers from New Delhi, they were drawn to Amravati, and the arguments were placed by both the parties on behalf of the government and on behalf of the farmers who challenged the legislation of three capitals. So many issues were raised: right to property, legitimate expectations, and legislative competence, because the AP Legislative Assembly has the right to decide where the capital should be situated. Like that, so many issues, so many issues. And finally, the matter was decided on grammar. It is plural or singular. So the provision in the AP Reorganization Act says that the central government should give financial assistance for a capital to the residuary state of Andhra Pradesh. Financial assistance for various buildings they have enumerated. So the word used, it is capital. So there is no question of capitals. Thanks to Justice M. Sachinand Murthy, he decided the entire case on the basis of one letter, yes, capital and capitals. So when the intention of the legislature, parliament is to establish a capital and to give financial assistance, where comes three capitals and giving financial assistance to three capitals? So this is before that, except on this, the arguments were on legitimate expectation, the arguments on agriculture, loss of agricultural produce, owners' rights, government contract, so on and so forth, for days together, days together. And finally, when the judgment came, the judge has simply stated that it is only capital. And hence, and also the act was passed by, AP Reorganization Act was passed by the parliament. So the state legislative assembly has no legislative competence to pass a legislation, and thereby Honorable Justice Sachinand Murthy has saved the 5 crore people of Andhra Pradesh, and also he set right the record. Because at times, even the judiciary will solve the political issues, the social issues. Anyway, legal issues will be decided by the judiciary and judiciary only. So in this intellectual tradition, that we have the privilege of witnessing the jurisprudence of Honorable Justice Ujjal Bhuyan. Sir, Justice Ujjal Bhuyan's judgments reveal an interpretative philosophy that is meticulous in textual analysis, sensitive to legislative purpose, and firmly anchored in constitutional principles. His decisions demonstrate that statutory interpretation is not an end in itself. It means to securing justice under the rule of law. In one of his celebrated decisions, where he has balanced the national security and individual liberty, in Syed Iftikhar Andrabi, National versus National Investigation Agency, Jammu, where the court considered the interplay between stringent provisions of Unlawful Activities Prevention Act and constitutional guarantee of personal liberty under Article 21. We know the case of Andrabi from the state of Jammu and Kashmir. The judgment reaffirmed that even the most rigorous statutory provisions must be interpreted harmoniously with the Constitution. So, no law is, even a special legislation, is above the principles and fundamental rights of the Constitution. It understood the right to a speedy trial is not eclipsed merely because the prosecution arises under a special statute. When there is a conflict between a special statute and the fundamental rights, Sir has balanced the both. In doing so, Justice Bhuyan demonstrated that constitutional values are not external to statutory interpretation. They are integral to it. The decision reflects the enduring principles that liberty and legality are not adversaries but companions to uphold the constitutional morality. So equally instructive is Mathu Elias Jagdish versus State of Uttarakhand, which speaks about the longest punishments that has been given to the accused, distinguished between different degrees of culpable homicide. Just like in US, there is sentencing commission and culpable homicide, there are different grades, and unnoticeably, though we are not following that sentencing commission or we do not have the grid of that punishment, but sir has beautifully demonstrated the different degrees of culpable homicide by closely examining the constitutional framework, evidence on record, and the surrounding circumstances. Like this, Honorable Justice Buyan has given several wonderful judgments. Undoubtedly, it is a joy to read his judgments, to learn the interpretation, philosophy, and somewhere there is a humane touch in his judgments. Thank you, sir. We have you on our apex court where you have been delivering the beautiful judgments. So, to cut short the story, Justice G.P. Singh's scholarship continues to inspire the discipline of interpretation of statutes. His writings remind us that interpreter must possess not only legal acumen, but also intellectual humility, historical awareness, and constitutional sensitivity. Likewise, the judgments of Justice Ujjal Bhuyan remind us that the majesty of the law lies not in its rigidity, but in its capacity to uphold justice without compromising the principle. That is the legislative intent. So, today's memorial lecture is therefore more than an academic event. It is a celebration of enduring conversation between scholarship and judicial practice. Justice G.P. Singh enriched the course through his scholarship, and Justice Ujjal Bhuyan enriches legal scholarship through his judgments. Together, they remind us the vitality of law depends upon constant dialogue between thought and action, between doctrine and decision, between principle and practice. On behalf of National Law Institute University, I extend our heartfelt gratitude to Honorable Justice Ujjal Bhuyan sir for graciously accepting our invitation. Sir, your presence among us is a source of immense inspiration to our students, and not only students, but also our faculty and all members present here. I also congratulate the organizers, the faculty members, research scholars, students, and every member of the university community who has contributed to making this memorial lecture possible. May this occasion renew our commitment to the ideals of constitutionalism, deepen our understanding of legal interpretation, and inspire us to pursue justice with wisdom, courage, and intellectual integrity. Before parting, I welcome all the dignitaries, and in particular, our Chief Justice, Chief Guest, and Honorable Guest of Honor, Sri Dagaji. And thank you. Jai Bharat, Jai Hind.
Thank you very much, sir. We now have the privilege of listening to a distinguished member of the judiciary. May I respectfully invite Honorable Shri Justice Vishal Dhagat, Judge High Court of Madhya Pradesh and Member General Council, National Law Institute, University Bhopal, to deliver the special address.
Good morning to all of you. Honorable Justice Ujjwal Bhuyan Sahab, Vice Chancellor, Justice Manan Sahab, Justice Ajit Singh Sahab, Justice Kemkar, Justice Pushpendra Kaurav, Satyendra Singh Saab, NP Singh Saab, and Principal District Judge, respected madams, academicians here, and students. Um, Today, I am seeing this list, so I have a special address. So we are all here to listen Justice Ujjal Bhuyan. And topic chosen for today is very relevant. It is court, state, and citizens. And today, I thank Justice Ajit Singh for inviting me here to speak. You all know about Justice G.P. Singh book, Interpretation of Statutes. This book is available in everybody's library, be it advocate, courts, or students. So he's a stalwart. He wrote many things. We all read this book to interpret. He was a great interpreter of statutes, and as per Constitution, it is the court who is the interpreter of Constitution. So today we will talk about state citizenship and courts. So first we will say I have given a book Bharat Matters, written by our minister, foreign minister. Bharat, that is India, that is what Constitution describes. And state is a concept, intangible thing. We cannot touch state. Uh, State is an idea. Uh, Article 12 defines state. It says parliament, legislatures, government of India, and municipalities, local authorities that are states. But state has not been defined anywhere. So, what is a state? State is having territories, geographical territories. States has population and citizen in which they live. Then state is having is a sovereign power. State do not follow anybody. Nobody challenges the authority of state. State का सिक्का चलता है. State has its own currency. Everybody agrees to it, follow it. So state is an idea, and state is run by government. State has three limbs. This is legislature, judiciary, and executive. And there is delicate balancing between all these three limbs to run state. So before we talk about state, we must know what is, sometimes we interchange words nation and state with each other. And sometimes it is used as state, sometimes we say nation, and sometimes both of stands for different things. Before we start about state, so foundation is preamble of the Constitution, sovereign secular socialist republic, that is India, and that is the basic structure of the Constitution, and that is the foundation on which India and states exist. State cannot exist without population. If population takes away, state will also go. So citizens are the basic for any state, and it is the citizen, we the citizens of India, constituted state, that is India. And without us, there will be no state. There is a balance. As we see, all power is concentrated in state. Army is with state, police is with state, executives are with state, legislature is also sometimes part of the state. So state is all powerful. When power comes, sometimes it corrupts, and sometimes you overuse it. State overreach sometimes, trample upon the rights of the citizens. So citizens are given rights in the Constitution of India that are fundamental rights. You all know, being students, what are fundamental rights. And fundamental rights are couched in negative uh, terminology. So it is for courts to put a rein on state when it overreaches and when it tramples upon the rights of the citizen. There are a number of cases when state has uh, trampled upon the rights of the citizen, and at that time court has come to their help, and they have stood for the citizens of India. Uh, Third is courts. If states and citizens function properly, they work dutifully, there may not be need of courts. When leaders, executives do not work properly, and there are differences between state and citizen, or when citizen do not work as per their duty and they do civil and criminal acts, then people and state they come to the courts, and now function of court starts. Before I say something more on this issue, uh, Constitution of India is separation of power between legislature, judiciary, and executive, and they function in different fields. Sometimes state overreach, sometimes they say court also overreach it functions, and citizens also they do not follow their duties and they do acts for which strict actions are required. uh, in this, I'll say before I start anything more, I'll say that Supreme Court has come to the aid of citizens many times, and Supreme Court has saved the rights of citizens. Initially, it started with Keshav Nandan Bharti. All students know it. All of us know about it. It said about the preamble of India. It is the basic structure, and it cannot be changed. It cannot be changed. Then next case which came, you all know about, is Menka Gandhi case. That is also very important case. It was in 1972. Passport of Menka Gandhi was taken, and matter came to the court. Court has that it is to be fair, reasonable, procedure has to be fair and reasonable, and authorities cannot act arbitrarily. Then third case is ADM Jabalpur versus Shivkan Shukla. Some says it is black chapter in the history of judiciary. You all know about it. And in that case, habeas corpus petition was filed in emergency time, and court could not stand for the citizens and said that habeas corpus cannot be exercised at the times of emergency. In this case, there was one dissenting judge. You all know about it. And later on, it was held that the judgment of dissenting judge in case of Puttaswamy, Justice Puttaswamy's case, that he was right and fundamental rights are to be guaranteed even in the times of emergency. Then came case of Indira Sawani. That is a reservation case. 27% reservation to OBC was given. Then again, matter went to the Supreme Court. Supreme Court interpreted the law and said that reservation shall not cross more than 50%. Creamy layer concept was also defined, and it also said that reservation shall not apply to scientific research matters and other technical matters also. In India, judgments are given in court, uh, rights are established, but actually it happens very late, that it comes to use in public sometimes 20 years, sometimes 30 years. Creamy layer has been defined, yet there is no strong steps taken, solid steps taken to define it properly. Still, people are taking advantage of it. Then there was another case of Supreme Court, that is Vishakha guidelines. You all know. In that case, there was a social worker in Rajasthan, Bhavari Devi. She was raped, and case went to the courts again. And at that time, court found that there was no guidelines for sexual harassment in workplace, and laid down the guidelines for, and later on POSH Act came, that it took almost 13 to 16 years for Act to come in force and legislator to legislate on it. So in India, progress happens slowly, and slowly it takes time, but change is brought by Supreme Court in many of the fields. Uh, Another case, other famous cases are Navtej Singh Johar. You all must have heard about it. LGBT community case, wherein decriminalization of same-sex relationship was said by Apex Court. Then again, there was famous case of Supreme Court, that is in India Young Lawyers Association versus State of Kerala. That is Sabrimala case. That is an ice-breaking case in India, and it gives some rights to women to visit religious places. Sabrimala case, I say that it was a ice-breaking case because it has some touch upon the religion. In India, generally, Britishers frown to bring changes in respect of religion and society. Before 1857, that is before revolt, Britishers did make changes in India. William Bentinck was there, Raja Ram Mohan Rai, Vidyasagar, Sati system was abolished, Pratha, and many other social evils were touched upon. But later on, after 1857, there was a revolt as soldiers revolted, did mutiny because uh, in gunpowder, in over cartridges, they used to use fats, and they say that it was against our religion, so there was great mutiny. After 1857, Britishers decided that we will not touch upon religion and society. So Supreme Court has touched upon this subject, and it said that though court cannot adjudicate upon religion and faith, but religious practices can be judged, and this was a wrong religious practice which was being adopted, and freedom was granted to women to visit the places. Now, this is under review also, and other practices, religious practices, are also under consideration. Similarly, Supreme Court come to the aid, triple talaq case, you all know. Then Shah Bano's case. In all these cases, practices were related to society, culture, and somewhat related to the religion. So Supreme Court adjudicated not on the basis of religion, but of religious practices which are being followed. Then there is Joseph Sine case. In it was a case when adultery was declared not to be an offense. Then lately, Article 370 was interpreted by Apex Court. Then Association of Democratic Reforms Electoral Bonds case came. Supreme Court in that case held that funding cannot be done. Uh, Companies Act, which places a section that there can be no cap, was removed. And then there was before we part with my lecture today, before the students, it is topic today is very apt because what is happening nowadays in India, you all know Cockroach Janta Party march to the parliament, and things happening, and court has to always take a delicate balance when to interfere, when not to interfere. Sonam Wangchuk was on hunger strike. His health deteriorated. Court interfered. It was cash 22 situation for court. He was taken to hospital and he was given feeding also. There is no law for force feeding, but then it is for state to save the lives of the people. So court interfered. Then he was also sent to the hospital of his choice. So courts are sometimes in very difficult positions, and words, courts are interpretation, court do interpretation of words, and words can play a havoc. Therefore, you have to be very careful when using certain words. And courts uh, courts are judges are also required to see, especially when they are speaking in a public function like this, that what they say and how it will be judged by listeners. uh, for citizens, since there was a march on parliament, and parliament is the sovereign authority to show our democracy and republicanism, and march to parliament was made in this case. And fundamental duties say that citizens must respect all democratic and republic institutions. So before we assert our rights, we must also take care that we must do our fundamental duty, since students are there, and they are the main force behind this. So I'll say to students that you go through your fundamental rights also, and also see fundamental duties. First you have to see what are your fundamental duties, then yes, you can assert your rights, whatever rights you want to claim. Courts has helped citizens to uh, in their fundamental rights, and they have safeguarded them. That's all I will say, and I will say to the students, this lecture series is for students. So I will tell them to listen carefully, not hear, listen carefully. When you will listen carefully, then only you can focus on the topic. Then you are required to do analysis, contemplate on what you are hearing, what you have listened, you have to analyze it. And third is you have to live upon it. So when you hear something, you listen it carefully, you make thought your own, you get familiar to it, and when you analyze it, you become master of it. If you do these two things, you will be successful in your profession, and you will be able to earn living. But when you do the third thing, that is when you live to that thought, then you will become great. Like Mahatma Gandhi, all of us, we say that we have to speak truth. We say and go back home. And he analyzed it, he adopted it in his life, practiced it, and once he practiced, he became great of all times. So for students, I'll only say that you listen carefully, analyze it properly, contemplate upon it, and try to live upon it. And we all are eager to hear Justice Bhuyan Sahab today. So that's all I'll say for today. Thank you. Thank you for listening.
Thank you, sir, for your insightful observations and inspiring address. We now arrive at the most awaited moment of today's program. To begin with, I take the privilege to introduce our esteemed speaker, Honorable Shri Justice Ujjwal Bhuyan, Judge Supreme Court of India. His Lordship was born on 2nd August 1964 at Guwahati. His father, Sachendra Nath Bhuyan, was a senior advocate and a former Advocate General of Assam. Sir did his schooling in Don Bosco High School, Guwahati, and thereafter studied in Cotton College, Guwahati. After graduating in arts from Kirorimal College, Delhi, he obtained his LLB degree from Government Law College, Guwahati, and LLM degree from Guwahati University, Guwahati. His lordship was enrolled on 20th March 1991 with the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram, and Arunachal Pradesh. Sir has practiced before the principal seat of the Guwahati High Court at Guwahati and appeared before the Agartala, Shillong, Kohima, and Itanagar benches of the Guwahati High Court. Sir also practiced before the Central Administrative Tribunal Guwahati bench and the Assam Board of Revenue. He appeared before the Labour Court Guwahati, various civil courts, and the State Consumer Forums, Arunachal Pradesh. He was the standing counsel of the Income Tax Department for 16 years, starting as junior standing counsel since May 1995 and subsequently appointed as senior standing counsel of Income Tax Department on 3rd December 2008. He was the additional government advocate Meghalaya in the principal seat of the Guwahati High Court from April 2002 to October 2006. He was engaged as special counsel of the Forest Department, Government of Arunachal Pradesh from December 2005 to April 2009. He was appointed as standing counsel of Guwahati High Court on 3rd March 2010. Designated as senior advocate by Guwahati High Court on 6 September 2010, he was appointed as Additional Advocate General, Assam, on 21st July 2011. He was a member of Guwahati High Court Bar Association, Lawyers Association, Guwahati Bar Association of India, All India Federation of Tax Practitioners, and Indian Law Institute, Assam chapter. Appointed as additional judge of Guwahati High Court on 17th October 2011 and confirmed on 20th March 2013. He was also the executive chairman of Mizoram State Legal Service Authority. His lordship was closely associated with the Judicial Academy, Assam, and National Law University, Guwahati. He was transferred to Bombay High Court and took oath as judge of Bombay High Court on 3rd October 2019. After a 2-year stint at Mumbai, Justice Bhuyan was transferred to Telangana High Court and took oath as judge of Telangana High Court on 22nd October 2021. He was the executive chairman of Telangana State Legal Service Authority, appointed as Chief Justice of the High Court for the state of Telangana, sworn in and assumed charge as on 28 June 2022. On 5th July 2023, the Supreme Court Collegium recommended the appointment of His Lordship as a judge of the Supreme Court of India. Whereafter, His Lordship was elevated as the Judge of Supreme Court of India on 14 July 2023. By virtue of being the Chief Justice of High Court for the state of Telangana, he also served as the Chancellor of the National Academy of Legal Studies and Research till his elevation as a Judge of the Supreme Court of India. Honorable Justice Bhuyan has continued his association with legal education. He is a member of General Council as well as Executive Council of National Law School of India, University, Bangalore. He is also a member of the General Council of Maharashtra National Law University, Aurangabad. His Lordship, your presence is a true honor for us. I respectfully request you to kindly deliver the Honorable Mr. Justice G.P. Singh 4th Memorial Lecture.
Senior Judge of the High Court of Madhya Pradesh, who is also member of the General Council of National Law University, National Law Institute, University, Bhopal, Justice Vishal Dhagat, Justice Purushendra Kaurav, former Judge of Madhya Pradesh High Court and now Judge of Delhi High Court, Justice Rajendra Menon, former Chief Justice of Delhi High Court and presently Chairman of the Armed Forces Tribunal, Justice Shantanu Kimkar, former Judge of the High Court of Madhya Pradesh and Chairman State Consumer Forum here, Justice Ajit Singh, my former Chief Justice of the Guwahati High Court, Sri Satyendra Singh, Lokayukta MP, Sri Narendra Pratap Singh, Upalokayukta MP, the Principal District and Session Judge, Bhopal, judicial officers who are present here, Professor Dr. S. Surya Prakash, Vice Chancellor of the National Law Institute, University, Bhopal, Senior Professor Dr. Gayur Alam, faculty members, family members of Justice G.P. Singh, and my dear students. A very good afternoon to all of you present here today. For me, it is indeed a matter of great honor and privilege to deliver today's lecture as part of Justice G.P. Singh's Memorial Lecture Series. As a young lawyer, in 1990s, the two most prized possessions in my chamber and which were gifted to me by my father were D.D. Basu's Constitution of India and Justice G.P. Singh's Principles of Statutory Interpretation. It is through this book that I got introduced, like many others, to the brilliant legal mind of Justice G.P. Singh. This book remained one of my prized possessions till Justice Ajit Singh, my Chief Justice, presented me with an updated version of the book, where the foreword was written by Ajay Singh and Justice Ajit Singh. The GP Singh that I knew from a reading of the book soon transformed into a more familiar figure as the good-natured Chief Justice made me, my wife Sangamitra, and my daughter Shweta a part of the family. I distinctly remember Justice Ajit Singh is very famous of, is very fond of non-vegetarian food. So it so happened that biryani used to come from Hyderabad. That tradition still continues. Recently we had again biryani from Hyderabad. Justice Singh said, I will keep the mutton biryani with me, you take the chicken biryani home. And the Chief Justice's residence there is very picturesque. It is on the bank of the river. And Justice Singh developed a habit of dictating judgments on the bank of the river. Anyway, Nirja Singh, whom we fondly called with respect Nirja ma'am, her affection and kindness also endeared her and the family to all of us. Soon, Jagat and Vaishnavi, at that point of time, Aditi had not yet joined the family, became part of our family. Through Chief Justice Ajit Singh, we also came in close contact with Ajit Dada, his elder brother and Bhabiji. There is a reference to Bhabiji in one of the forewords of Justice Ajit Singh when she requested him to about this, I think Ratanlal Dhirajilan's law of torts. I think she was a member of the State Consumer Disputes Redressal Forum. I distinctly remember on one or two occasions during our visits to Bhopal, when we had met them, we shared meals together. Much after Chief Justice Ajit Singh left Guwahati on demitting office, in a family get-together, my younger sister, who is an ophthalmologist, told me that recently she had met Dr. Harsha Bhattacharya. Those who come from that part of the country will recollect or remember Dr. Harsha is one of the outstanding ophthalmologists of this country. He is presently with the Shankar Netralaya at Guwahati, who told her that he had an occasion to visit the High Court and met the Chief Justice. In the course of their conversation, he said, the Chief Justice mentioned about me and told Dr. Harsha that I was the best judge in Guwahati. On hearing this, I was a young judge then. I felt very happy and also vindicated. It bolstered my confidence. I also fondly recollect that Justice Ajit Singh frequently used to tell me and many others that my judgments used to remind him of his father's judgments. A great compliment indeed. To be compared to the legendary judgments of the legendary G.P. Singh is indeed a great compliment. It goes without saying that such words of appreciation from your Chief Justice is really inspirational, and it did inspire me. As I matured into my judgeship, I started heading division benches in Guwahati, then in Mumbai, and then in Hyderabad. In each of these three places, I tried to pass on whatever little I knew to my bench partners. Today, as I look back, it gives me immense satisfaction whenever I come across good judgments authored by my colleagues who had shared the bench with me and who acknowledges that in one way or the other, I had mentored them. As I look back today, I do think that Chief Justice Ajit Singh did try to pass on one message or the other to me, particularly when I was heading the bench dealing with issues of citizenship. There's a very peculiar issue out there. There's a dedicated bench which deals with citizenship, which is a very sensitive issue there. For whatever reason, I could not properly comprehend at that point of time the message that he was trying to pass on to me. Recently, in our summer vacation, we had gone to London, and coming to know of my visit there, some professors from Queen Mary University, which is an important university, they said, "Sir, why don't you come over for a cup of tea and we'll have a frank discussion?" So I said, if you want to have a frank discussion, then please make it a closed event, no recording, because back home there will be a lot of criticism. Though I am a part of the Supreme Court, I am an insider. I am critical of the functioning of the Supreme Court to a great extent, and I don't mince my words. Perhaps for this reason, some are not happy, but we leave it at that. In that interaction with the Queen Mary University's students, researchers, and teachers, I said, they asked me, "Sir, what do you think? Do you have any regrets? What is it?" I said, "I have completed about 16 years of judgeship now." Jokingly, I said, for a judge, the first 5 years, he is very unsure. He doesn't know. He thinks whether his orders passed are correct or not. He's very unsure. Next 5 years, he becomes overconfident. He thinks what every order passed by him is correct. Next 5 years, he becomes totally indifferent. Right, wrong, he will pass orders. So this is the fate of a judge. But that apart, I said, as I look back today, I won't say wrong, many of my decisions, whether on the administrative side or on the judicial side, could have been done in a different way. Same thing, if those are given to me now, I would certainly do it. I would have certainly done in a different thing. Perhaps that was the message Justice Ajit Singh wanted to pass on to me, but for whatever reason, uh, I could not properly comprehend at that point of time. We leave it at that. All that can be said is that Chief Justice Ajit Singh had a very successful tenure of more than 2 years, and during that period, the High Court gelled as one family, thanks to the collective leadership that he encouraged. The High Court did really well, and this was acknowledged nationally by the Supreme Court, several judges of the Supreme Court. One incident I would like to mention, we are all out of Guwahati now, would like to mention, is about the wedding reception of Jagat and Ariti at Jabalpur. At that time, I was the Chief Justice at Hyderabad. The wedding was on a weekday and was at Orcha. There were communication problems with it. Therefore, it was not possible for us to travel from Hyderabad all this way during a working day. But the reception was fixed on, subject to correction, February 16, 2023. 16th February? Oh, you have forgotten. All right. Which was a Saturday. So we decided to come, myself and my wife. But it so happened that by virtue of my office, I was the Chancellor of Nalsar, University of Law. Much earlier, we had decided that we should have the convocation, but we left it. We decided that we should have the Chief Justice of India be the convocation speaker. So we requested the then CGI, Justice D.Y. Chandrachud, so please come and deliver the convocation address. He said, my office will let you know. It so happened that he chose February 16 as the convocation day, that he would come to Hyderabad and deliver the convocation address. So we were in a great dilemma, what to do. We had to come and attend the reception, then the convocation was there. And as the Chief Justice, as the Chancellor of Nalsar, if I am not there to welcome the dignitaries, what will happen? The Chief Justice of India and two senior judges of the Supreme Court, they arrived. Justice Ram Subramaniam and Justice P.S. Narasimha, they arrived at Hyderabad. In the meanwhile, I had checked, and I found that there was an 8-hour flight from Hyderabad to Jabalpur at 4:30 in the evening. And it returns back the next day around 8 o'clock in the morning. We took our chance and booked our flight tickets. CGI and his group came, Hyderabad. Convocations, luckily for us, convocation started on time at 11 o'clock. And by the time we had lunch together, it was 2 o'clock over. And the CGI and his team decided that we'll go to Sri Sailam to visit the temple there, and that he will come back the next morning. So the moment CGI and his team left for Sri Sailam, we rushed to the airport, took the flight from Hyderabad to Jabalpur. We reached around 6:30, attended the wedding reception. Next day, early morning, we went back to Hyderabad and was ready at the hotel by 10:30 to welcome the CGI back, on way back from Sri Sailam. Today, as I look back, I feel a sense of fulfillment at the success of our adventure. But I shudder to think as to what would have happened if the flight from Jabalpur to Hyderabad had got cancelled or had got delayed. So these are the imponderables of life. Sometimes it clicks, sometimes it does not. In life, so also in law. So thank you, Justice Ajit Singh and the family, for your kindness and warmth in inviting us to this beautiful city of lakes and to this green campus of NLIU Bhopal. Justice Guru Prasanna Singh was of India's most distinguished judges and jurists. He served as the 8th Chief Justice of Madhya Pradesh High Court from 1978 to 1984. During this period, he also briefly discharged functions of acting governor of MP on 2 occasions, in 1981 and in 1983. Even after demitting office, he continued to contribute to the administration of justice as the chairman of the Madhya Pradesh Law Commission and later as a Lokayukt of Madhya Pradesh. Born on January 3, 1922 at Raipur Karchulian village in Rewa district, Justice Singh received his early education at the Central Hindu School, Benares. He pursued his higher education in the Benares Hindu University, where he obtained his Master of Science in 1941, securing the first position. He subsequently obtained his law degree from the same university in 1944. After his enrollment in 1954, in between he was a lecturer, Justice Singh began his legal practice before the Rewa Judicial Commissioner's Court, when he also served as a lecturer in the Government Law College. Following reorganization of the states and establishment of the Madhya Pradesh High Court, he shifted his practice to Jabalpur. On November 7, 1967, he was appointed as an additional judge and later on as permanent judge on July 29, 1968. As has been pointed out by Justice Bhagat and the Vice Chancellor, apart from his judicial career, Justice Singh made an enduring contribution to Indian legal scholarship through his seminal work, Principles of Statutory Interpretation, which remains one of the most authoritative and widely cited treatises on statutory interpretation in India. In fact, the name of Justice G.P. Singh has become synonymous with statutory interpretation with this book. It so happened when I had gone to Bangalore a couple of years back to meet Justice U.L. Bhatt, who was my Chief Justice then, who also was a Chief Justice here. In the course of our conversation, he asked me, who is your Chief Justice now? I said, Justice Ajit Singh. Then he said, oh, the son of that, he was searching for the name, maybe because it's old age. That's statutory, principles of statutory interpretation, and that's G.P. Singh's son. So G.P. Singh became synonymous with this book, even now. He has also edited with great finesse Ratan Lal and Dhiraj Lal's The Law of Torts. I have with me a copy of the updated 26th edition of this book, possibly the last time Justice G.P. Singh edited this 8th book. Justice Singh had built a formidable reputation of authoring clear and structured judgments. Justice A.K. Patnaik, former judge of the Supreme Court of India, writes Justice G.P. Singh's judgments are of high quality, though shorn of any verbose or unnecessary quotations, and are straight on the point. Mr. P.P. Rao, senior advocate, while recollecting the contributions of the Madhya Pradesh High Court to the development of law, referred to Justice G.P. Singh with great deference and said that his judgments are known for their quality and precision and are worthy of emulation by others. Therefore, it is not surprising that a book has been published titled Justice G.P. Singh Select Judgments, a tribute to his craft, method, and style, published by LexisNexis, Buttersworth, Vadua, Nagpur, with a foreword by Justice A.K. Patnaik. Justice G.P. Singh passed away on 5th October 2013, leaving behind a lasting legacy as a judge of unimpeachable integrity, a jurist of exceptional caliber, legal scholarship, and an unwavering commitment to judicial independence. He is widely regarded as one of India's finest judges, who most unfortunately was not elevated to the Indian Supreme Court. There are reasons which are there. It's not, it won't be, I won't like to go into those reasons today. But one thing is clear, it is not only Justice G.P. Singh. Such omissions continue to plague the Indian Supreme Court even today. This is another topic we will discuss some other day, not today. Justice Markandeya Kajju has described Justice G.P. Singh in the following words, and I quote, "One of the legendary judges in India was Justice G.P. Singh. He was a judge of the highest integrity and principles and was also profoundly learned. His book, Principles of Statutory Interpretation, is still regarded a classic. He was senior of Justice J.S. Verma, who later became the Chief Justice of India. Justice G.P. Singh deserved to be made a Supreme Court judge by any standard. This sentiment is widely echoed and shared. George Gadbois Jr., who was the research guide of Abhinav Chandrachud, in his book, Judges of the Supreme Court of India, also acknowledged Justice G.P. Singh's professional reputation. He said Justice G.P. Singh had an excellent reputation, but he had run afoul of the government, in particular by refusing to accept certain government nominees for judgeship. This trend continues till date. On this occasion, I pay my respectful homage and tribute to this exceptionally principled, independent, and scholarly judge, whose contribution to Indian jurisprudence extends well beyond the bench. Before I start my oration, a word or two about this university. This is my first visit to the university. In a span of over 25 years, this university has established itself as a center of learning and excellence. It has done commendably well, for which the faculty and the students deserve all the praise. But one word I would like to put in. This university has done exceptionally well. There are many universities which are doing well. Question is, where do the Indian universities stand today on a global comparison? Why is it that people with means, the first thing they do is to send their students, as to send their children abroad? Why? We need to ask this. The other day, I was invited by another national law university to the induction program of the new batch of students. I requested the university that allow the students to be themselves, encourage their inquisitiveness. Students should be encouraged to question. Unless students question, they will only be parroting the texts and they will become like a captive audience. Captive audience, I say, when a high court judge speaks, the district judges are there, the district judiciary, the judges from the trial judiciary are there, and they are not questioned. Everything is being asked or everything being said is being lapped up. So our students need to be critical, need to question, including the judiciary. Judgments, after being delivered, are required to be critically examined and criticized if necessary. Criticism of a judgment does not amount to criticism of a judge. Recently, on an arbitration conference, I was there in Delhi High Court. I said about one of the recent judgments of the Supreme Court in Delhi Metro. I said about this. I said this judgment has sent shock waves in the international community, arbitrators and those investors. As if taking a cue from this judgment, the government of the finance ministry has issued a circular saying that above 10 crores, no arbitration. ONGC, Oil India, they have followed suit. No arbitration beyond 10 crores. Delhi PWD has said, henceforth, no arbitration, go to civil court. When we have a statute, Arbitration and Conciliation Act, when the Prime Minister says that our objective is to make India a global hub of arbitration, to make ease of doing business great in India. Now, how can we expect people to come to India for arbitration when you have erratic court judgments and such regressive government policies? The law minister, way back in 2016, had said, I go to Singapore Arbitration Center, I go to Hong Kong Arbitration Center, I see parties are Indians, the subject matter of dispute is Indian, the two lawyers are Indian, two sets of lawyers are Indian. Why are they going to Singapore? Why are they going to Hong Kong? Mr. Law Minister, this is the reason. Who will come here? 34 petition in Delhi High Court takes about 3-4 years. Bombay, it takes 5 years. These are the two major high courts there, insofar as arbitration is concerned. Then we have 37, 136, review, then occasional curative jurisdiction. So these are the issues our students need to question the judgments. The recent judgments, for example, EWS judgment, the economically weaker section judgment, needs to be critically examined. There are people say there are fundamental, I'm saying as a student of law, there are fundamental flaws in this judgment. It needs to be analyzed. The judgment needs to be. Unless we do that, how do we improve? If everybody goes and tells the judges, sir, wonderful judgment. Sir, what you say is excellent. Sir, you are a jurist. Then nothing, how will the system improve? So that is why I say our universities should have that much of autonomy, at least academic autonomy, to explore or venture into uncharted territory. I told the students, you are young people, you have a free mind, think it that way. Palestine, India has recognized Palestine. We have a Palestinian embassy in India. Traditionally, India has always recognized Palestine. The recent incidents in Gaza, for example, it is South Africa who has moved the International Court of Justice against what is happening there, saying that please make a declaration that it's a genocide. Justice Muralidhar of the Delhi High Court, former Chief Justice of Orissa, UN appointed him as the chairman of a committee to go into this violence in Gaza. He has published a report which is accepted by the UN. It is now in the public domain about the violence meted out by the state on such children and women, elderly people, sick people in Gaza. These are issues. I'm not saying that only these issues should be debated. These are the issues which should agitate the young mind of a student, of a research scholar. You must read, you must question. That is the place of a university. And I found it very amusing when in Bombay, Shivaji Park, a group of people wanted to demonstrate in solidarity with the people of Gaza. The permission was not granted by the government. So they moved it in the Bombay High Court. The learned judge said, don't you have any issues in India? Why do you have to go that far to agitate? It's really very, very amusing to say the least on this. So therefore, friends, I urge upon the university community to allow this critical aspect of a student instead of, because I'm saying this because I'm told one of the NLUs had taken punitive action against a student for asking questions. Universities should be seen as encouraging students to engage in debate, to engage in uncomfortable questions. Comfortable question, everybody can ask, everybody can answer. These are uncomfortable questions and not seen as curbing or stifling such voices. Having said that, the preface actually took a bit of quite a long time. Let me come to the topic of my oration today. I will be very short here. It is state, courts, and the citizens. Before I dwell on the functioning of the courts and the expectations of the citizens from the courts, let me briefly touch upon the doctrine of separation of powers. Justice Dhagat has said that, which is a foundational principle in almost all democratic societies worldwide, including India. This principle ensures that the three branches of the state, we all know, legislature, executive, and the judiciary, are clearly demarcated, thus preventing any one organ of the state from having unbridled and unchecked power. This framework is essential to uphold the rule of law by ensuring an effective system of checks and balances. Historically, this doctrine was conceptualized as a response to autocratic rule, where the monarchs exercised absolute power The Greek philosopher and polymath Aristotle, in his book, The, the Politics, noted that a functional state comprises three critical elements. First, one that deliberates on public issues, the second that oversees administration, and the third that adjudicates disputes. This is Aristotle in BC. John Locke, the famous English philosopher, also known as the father of liberalism, made a substantial contribution to this doctrine. In his book, Two Treatises of Government, it is 1690, he advocated for the separation of legislative and executive powers, emphasizing that distinct governance rules help safeguard civil liberties and prevent authoritarianism. This doctrine gained momentum after Montesquieu, a French judge and political philosopher, articulated the theory of separation of powers in his landmark book, The Spirit of Laws, in the year 1748. He coined the phrase "trias politica," which also means checks and balances between three branches of the government. An example of trias politica is that of a three-legged stool, where each leg represents a particular organ of the state, that is, legislature, executive, and the judiciary. Thus, a three-legged stool would remain strong and effective if all the three legs remain strong independently. If there is asymmetry in alignment, there is the danger of the stool falling apart. The three are placed at equidistance. If we have two legs at one place, the stool will fall apart. It will fall down. This is the fundamental principle. Therefore, when a former Chief Justice of India says, I am going to the Rajya Sabha to bridge the gap between judiciary and the executive, it is fundamentally wrong. It is completely wrong fundamentally. It goes against the principle of separation of powers. There's a fundamental fallacy there. As articulated by Montesquieu in that Spirit of Laws, the doctrine of separation of powers is crucial for safeguarding the rule of law and the freedom of the citizens, because he was of the view that there can be no liberty where the legislative and the executive powers coalesces in the same person. Globally, countries have adopted varying degrees of separation tailored to their conditions and historical context. In the case of India, the doctrine of separation of powers is not enshrined explicitly in the Constitution, as in the United States, where the doctrine is a clear-cut structural element of governance. Instead, India adopts a more fluid and flexible approach influenced by British constitutional principles, which do not advocate for a strict watertight separation, but rather a system of checks and balances. This approach has led to a unique implementation of the separation doctrine, characterized by significant overlap and interaction amongst the three branches of governance. However, the Constitution provides that in matters of interstate disputes or disputes between the three organs of the state, or the interpretation of constitutional principles, the final say will be that of the Supreme Court. Therefore, the position of the Supreme Court is unique. While maintaining the federal and institutional balance, the Supreme Court has an edge inasmuch as it is the final arbiter, and by virtue of Article 141, its decisions are binding on one and all in the country. Therefore, the Supreme Court is the guardian of the Constitution and the Republic. It is the sentinel on the qui vive. Friends, I am not competent. Rather, it would be inappropriate for me, as a sitting judge of the Supreme Court, to comment on the functioning of the legislature and the executive. Therefore, I would refrain from doing so. However, I can certainly say a word or two about the judiciary, its functioning, and the expectations of the citizens from the Indian judiciary, more particularly the Supreme Court of India. Of course, keeping in mind my limitations. Friends, let me turn a few pages back in history. We go back and forth. The Guwahati High Court, of which Justice Ajit Singh was the Chief Justice, was initially established as the Assam High Court. It was the first High Court of independent India. Ironically, the first Chief Justice of the first High Court of independent India was an Englishman, Sir Ronald Francis Lodge. If you read Fali Nariman's autobiography, Before Memory Fades, you will find a brief reference to this in the book. Inaugural function was held on 5th April 1948. Sir Harilal Kania, the then Chief Justice of the Federal Court, presided over the function and delivered a widely reported speech. In that speech, he not only broke a tradition of judicial reticence, but importantly, he highlighted the need for judicial independence, which perhaps he felt constrained as a member of the colonial judiciary. Chief Justice Kanya's speech was one of several public and private initiatives by the Indian judges to shape the contours of the draft constitution that was then being debated in the Constituent Assembly. Archival materials show that almost all sitting judges, whether in the High Courts or in the Federal Court, actively pushed for changes in the draft constitution, highlighting the need for an autonomous judiciary. Upon reading portions of the draft constitution, Chief Justice Ramlal of the East Punjab High Court got so visibly agitated that he wrote directly to Pandit Jawaharlal Nehru, expressing his concerns about certain provisions dealing with the judiciary, which he thought had the potential to undermine the independence of the judiciary. Nehru forwarded it to the Constituent Assembly Secretariat. Perhaps anticipating a flood of such correspondences, the Secretariat officially invited all High Court judges to submit their views on the draft constitution. Close to 100 High Court judges offered individual feedbacks, while some of the High Courts additionally offered collective statements. The judges, collectively and individually, stressed upon the need for judicial autonomy, uncompromised by the power of a popularly elected executive. Justice Shiude of the Nagpur High Court, Nagpur has now become a bench of the Bombay High Court, very lyrically he wrote that the executive in a democratic state was bound to be a fluctuating body. Like the clouds, it may come, it may go. Therefore, the executive should not be allowed to exert its influence over the judiciary by arrogating the power to control it. Supreme Court's coming into existence coincided with the coming into force of the Constitution of India. It had its first sitting with all the 6 judges in attendance then on 28 January 1950, 2 days after India became a republic. During the inaugural sitting, Justice Kania, as the first Chief Justice of India, delivered a speech outlining the broad contours of the Supreme Court. He emphasized 3 essential principles for the Supreme Court. First, he stressed the importance of an independent judiciary, asserting that Supreme Court must operate independently of the legislative and the executive branches. Second, he highlighted the need for a flexible judicial approach to adjudication, which is not fixated with the textual content. In other words, Supreme Court should interpret the Constitution not as a rigid set of rules, but as a living entity. Lastly, and most importantly, he said the Supreme Court must earn the respect of the citizens to establish itself as a legitimate institution. This foundational vision, highlighted by Chief Justice Kania, signifies that Supreme Court was meant to be more than a legal body, as it is to serve as the moral compass and the constitutional conscience of the nation. By insisting on independence, it ensures that the judiciary can check misuse of power by the legislature and by the executive, safeguarding democracy and individual rights. The call for a flexible, evolving interpretation means that the Constitution would remain relevant to changing societal needs, allowing the judiciary to drive progressive reforms. Finally, the emphasis on earning public respect underscores that judicial power relies not just on law, but on trust and legitimacy, making accountability, integrity, and transparency essential for the judiciary to function effectively in a democratic society. Friends, it has been more than 75 years since the Supreme Court started functioning. During this long period, several important and path-breaking judgments have been delivered by the Supreme Court. I am not going to refer to all those judgments. Justice Dhakat has already referred to quite a few of the judgments, so I'm not going to refer to all those judgments. I only take the liberty to mention about one judgment, which I think is the most important case, and that is the case of Keshavananda Bharati. A 13-judge bench of the Supreme Court, the highest so far, laid down a simple but a significant constitutional principle that the Constitution of India has certain essential features which form its basic structure. The majority held that by exercising the power of amending the Constitution under Article 368, any provision of the Constitution can be amended. That power the Parliament has got. But in the process of amendment, the basic structure of the Constitution cannot be altered. There is a history to this. I will not go into all this. Shankari Prasad, Sajan Singh, then Goloknath, then this Keshavananda Bharati, followed by Minerva Mills, and so on and so forth. This judgment has stood the test of time. It has been applied more than a dozen times by the constitution benches of the Supreme Court. So it is wrong when the then Vice President of India questions the jurisprudential legitimacy of the judgment. It is wrong. It has stood the test of time. It is also wrong when a former Chief Justice of India asserts in the Rajya Sabha that I am not very sure of the jurisprudential foundation of this judgment. This judgment has stood the test of time. And the essence of this judgment is the Constitution cannot be used to mutilate and destroy itself. That is the essence of this judgment. You cannot use the Constitution and to destroy itself. The learned judges, after mentioning certain features as essential features, forming the basic structure, however, did not foreclose the list of basic structure. They kept the list open-ended. But they listed out something, and which was followed by other judgments: rule of law, independence of the judiciary, judicial review, separation of powers, federalism, democracy, periodic elections, etc., have been read, interpreted, and held as forming the basic structure of the Constitution. Though it is the constitutional duty of all the three organs of the state to uphold the Constitution by ensuring that the basic structure of the Constitution does not suffer any assault, ultimately it is for the judiciary, and more particularly the Supreme Court, to ensure that these essential features are protected. I ask myself, if the judges do not protect independence of the judiciary, who else will protect? If the judges do not enforce the rule of law, who else will? Today, we find many people taking law into their own hands, making hate speeches, doing this, doing that, with impunity. Why is it? We need to ask ourselves. The judges need to ask themselves. Coming back to the basic structure doctrine, I have to mention about a distinguished German jurist, Dietrich Conrad. Conrad was the head of the law department in the University of Heidelberg. Recently, in the vacation, we had the good fortune of visiting this town of Heidelberg, which is very near to Frankfurt. This university is of 1386 vintage, mind you, 1386 vintage, this university. Subject to correction, it has produced 54 Nobel laureates. That is the question. I go back. Why Indian universities are not producing academics and scholars of this repute? Where have we gone wrong? So Professor Conrad, he came to India on an invitation and he visited the Banaras Hindu University, law department of Banaras Hindu University. In February 1965, he delivered a speech. In that lecture, Professor Conrad spoke about the implied limitations of the amending power of a constitution by giving extreme examples, such as he asked, could a constitutional amendment be passed abolishing Article 31 or abolishing the Constitution altogether and reintroducing British rule? Is it possible? Obviously, these were extreme and patently unreasonable illustrations. But these extraordinary exhortations made the larger point that there ought to be limitations on all powers exercised by the institutions, including the amending power, and there ought to be checks and balances to ensure such limitations. Therefore, we go back to the doctrine of separation of powers. Therefore, we go back to the example of the stool with three legs. If there is asymmetry in the three legs, the stool will collapse. Conrad's fundamental conclusion was any amending body organized within a constitutional scheme setup cannot, in its very structure, change the fundamental pillars supporting the constitutional authority. It cannot. In his lecture, Professor Conrad referred to Germany's Weimar Constitution. It's very important. And explained how Hitler came to power using the emergency provisions of that very constitution so that the constitution could be used to destroy itself. And when Hitler did this, as the chancellor, when he hollowed out the constitution of Germany, the German courts remained silent. Either they look this way, look the other way around. Some say they actively participated in such mutilation. I'm reminded of this movie, Valkyrie, I think. Valkyrie is the movie, yes. During the war, some within the German armed forces thought that we had enough of all this. It's time we get rid of this person. But the mission failed. This is how the movie, of course, it's a movie, there has to be some natural exaggerations. And all of them were captured. But that's not the issue. The issue is, there's a scene which shows a German judge. The way he reacted to these people, it showed as if he would take the gun and he will shoot them himself. This was the state of the German judiciary at that point of time. And this was what Professor Conrad had in mind when he emphasized on the doctrine of basic structure, saying that do whatever you feel like, the essential features of the Constitution cannot be changed. This is the essence of the judgment. Friends, I won't take much longer. We all know that the judiciary has neither the purse nor the sword. The only thing that the judiciary has and which sustains it is the faith of the people. This is what Chief Justice Kania had said when he spoke about legitimacy. For the judges and the judiciary to remain legitimate and to remain relevant, public perception is most crucial. It amazes me when we go on ourselves patting our own backs by saying how powerful the Indian Supreme Court is, how great Indian Supreme Court is. Undoubtedly, it's a great institution. Generations of judges have built brick by brick to build this great institution. But it is not for us to make that comment. It is for the citizens to assess. Perception of the citizens as to where the judiciary stands today, more particularly the Supreme Court, 75 years after we have become a republic, is what matters. On November 18, 2024, I attended a roundtable conference at the Constitutional Club, New Delhi. It was organized by Mr. Kailas Satyarthi and his Bachpan Bachao Andolan. Satyarthi wants to bring in an element of what he calls the compassionate quotient in justice delivery. So a roundtable discussion was held on the topic, role of compassion in achieving justice for all. A number of sitting and retired judges were present in that conference. about 5, 6 retired judges, about 10 sitting Supreme Court judges were present, including Justice Gawai and myself. As I was listening to them, I was asking myself as to what could be the reason for having such a conference. Is it because there is a public perception that somewhere down the line, the courts or the judges are no longer seen as sensitive or compassionate or responsive towards the people? In that conference, when my turn came, I praised the bulldozer judgment of Justice Gawai, forbidding demolition of houses and premises by using bulldozers. But I said, it's a good judgment, no doubt. But it has come 2 years too late. It should have come 2 years earlier. You may also ask, what is the impact of this judgment? I would say practically nil, zero. With virtually zero impunity, residential houses and small business premises are being demolished by using the might of a bulldozer. In Pune, I had spoken about this and I said, when you use a bulldozer, it is like bulldozing your constitution. It's like bulldozing over your constitution. In that conference, I spoke about the need for judicial introspection. I had said, only if we introspect, we will be able to see or find out our shortcomings. I asked myself, I asked the group there, could the Supreme Court have done better regarding the migrant workers during the pandemic? Could it have done better during those testing times? We need to have a candid conversation on this. We need to find out our shortcomings or where we had gone wrong. It is only then there can be course correction. Building up on this, in my judgment in Wikimedia Foundation versus ANI Media, I said that for the improvement of any system, and that includes the judiciary, introspection is the key. That can happen only if there is a robust debate, even on issues which are before the court. Both the judiciary and the media are the foundational pillars of democracy, which is a basic feature of our constitution. For a liberal democracy to thrive, both must supplement each other. Friends, it will not be an exaggeration. I will not comment on any contemporary happenings in the country. I'll refrain from doing so. But it will not be an exaggeration to say that public space for expressing divergent opinion is shrinking in India. The right to express one's views and to demonstrate peacefully are fundamental freedoms of the citizens. Debate and dissent are the essence of democracy. Unfortunately, even normal activities are being criminalized. People who come to voice their anguish over environmental degradation, which is a reality, are chased away as if they are criminals. Students protesting in campuses are arrested and they do not get bail for 30, 40 days. They are suspended, for which they have to go to the court. It takes time. These issues raise serious questions. Citizens are finding that though the courts are responsive and do grant bail, do grant relief, many a times it is belated. But it is the restrictive conditions which are imposed while granting bail that are causing the greatest concern. By such restrictive orders, are the courts indirectly telling the citizens or discouraging the citizens not to express their dissent? It, it is not confined to any particular case. Take, for example, the case of a group of youngsters breaking their fast over the river Ganga by consuming chicken biryani. I'm sure consuming chicken biryani is not an offense, can't be an offense. There is no law prohibiting consumption of chicken over the Ganga river. They were arrested for that reason, very reason. And they had to remain in jail for three months. 3 months. Can you imagine? It took 3 months for the courts to grant them bail. Can people be arrested and denied bail for 3 months for such an activity? I ask myself. Citizens are watching. The world is watching what is happening. For putting up a post on Facebook commenting on the conduct of a minister who had called a serving Indian Army officer daughter of a terrorist only because of her faith. An FIR is lodged. He had to seek anticipatory bail. Anticipatory bail is granted by the court, no doubt about it. It's granted. But what does the court do? Deposit your passport. Hurry, it's not a flight risk. Deposit your passport. Don't post any other your Facebook post or attend any public meeting or give speeches on this regard. Take the case of young student activists who had suffered long incarceration. While the court granted them bail, they were directed not only to surrender their passports, but also not to participate or address any public meeting, whether in physical form or virtually. Imposition of such restrictive conditions severely undermine their fundamental freedoms and liberty. People would be justified in asking as to whether by passing such orders or by imposing such restrictive conditions, is the court also sending a message that do not participate in such public activity? The Supreme Court Bar Association, they had a conclave in Bangalore this March on various issues confronting the courts and the lawyers. I was also invited, and I was also part of that conclave. Myself and my wife, we took out some time from the conclave and visited Justice Venkat Chalaya, who resides in Bangalore. I believe Justice Venkat Chalaya is one of the last surviving great Chief Justice that India had. We had a very cordial discussion on various topics concerning the judiciary. At the end of our conversation, both of us agreed he's 30 years senior to me. Both of us agreed that the present generation of judges it is for the present generation of judges to uphold the Constitution and its constitutional spirit. If they cannot add to that, or if they cannot carry forward the good work done by the previous generation of great judges, at least we should not undo the great work done thus far. Friends, this is where we stand today. You may find my oration a little bit depressing, but I am an eternal optimist. I have great faith in the young lawyers of this country. I am inspired by the young and vibrant law students of our country. From my interaction with them, I can certainly vouch for the fact that the new generation of lawyers and law students, who are future generation of lawyers, are far more committed to the rule of law and to the Constitution than my generation was. That much I can say. I see great hope in them. And I'm sure it is they who will ensure that Indian courts do not deviate from the foundational vision of Chief Justice Kania. There are vast majority of people who believe in the judiciary. There are hard-working judges, whether at the trial courts, at the district court, at the high courts. They work day and night. They are hardworking. They have no godfathers. It is through their good work that Indian judiciary has survived 75 years. I believe it is through the good work of these judges, the unheard of judges, the unspoken judges, the collective initiative of the citizens, lawyers, and the law students, which will ensure that the Indian judiciary retains its relevance. Thank you very much, and God bless.
Thank you, Your Lordship, for delivering such an enlightening, thought provoking, and intellectually enriching memorial lecture. Your profound reflection on the relationship between the state, the judiciary, and the citizens have undoubtedly inspired everyone present today. As a humble token of our gratitude and deep respect, we shall now felicitate our distinguished chief guest. May I now request Professor Dr. S. Suryaprakash, Honorable Vice Chancellor, National Law Institute, University Bhopal, to kindly felicitate our Honorable Chief Guest. We now move to another significant moment of today's program, the release of the latest edition of the National Law Institute University newsletter, reflecting the university's academic achievements, research initiatives, and institutional milestones. May I respectfully request our honorable dignitaries to kindly release the newsletter. As we approach the conclusion of this memorable event, It is now time to formally express our gratitude to everyone who has contributed to making today's program a grand success. May I now invite Senior Professor Dr. Gayur Alam, National Law Institute, University Bhopal, to propose the vote of thanks.
Thank you, Dr. Seema. Good afternoon, everyone. Honorable Mr. Justice Ujjal Bryan, Chief Guest of the event. Honorable Mr. Justice Vishal Dhagat. Honorable Mr. Justice Shri Pushpendra Kumar Kaurav, who is known as an intelligent and a very sharp judge from Madhya Pradesh in Delhi. So, sir, we are very thankful to you for raising our flag. Honorable Mr. Justice Rajendra Menon, presently Chairman of Armed Tribunal and former Chief Justice of Delhi High Court. And also, sir, you are with the Legal Education Committee of Bar Council of India. I have a request that do something for legal education. Honorable Mr. Justice Ajit Singh, Professor S. Surya Prakash, Honorable Justice Satendra Singh ji, a former member of EC General Council. Pushpendra Kaurav ji was also our member of EC and General Council. Lokayukta of Madhya Pradesh, Shri Satendra Singh ji, NP Singh ji, Principal District and Session Judge Bhopal, our own Vice Chancellor, who is the man behind everything, our family of Justice GP Singh, his elder son, Mr. Ajay Singh, who was member of our IQAC for some time. Ladies and gentlemen, respected madams, my colleagues, dear students, and if I forget anyone, please forgive me. My apologies, because what happened, I was delivering vote of thanks after that. A colleague of mine said that you didn't take my name, so my apologies to everyone. There were two main addresses, and there's one common point. Though we are late, there is one biological hunger and the intellectual hunger. So, sir, with your permission, though I have been instructed to speak for 2 minutes, so I'll seek your permission to say something. That the focus was on role of judiciary, both as an institution and role of judges. Because one of the points that our chief guest made today, if judges don't, who else? Is a big question. And when citizens, they do not have any redress from anywhere where they can go. We are celebrating the legacy of Professor G.P. Singh, Shri Guru Prasanna Singh, who was not Guru only in name, is a Guru to most of us. We have read his book, true to his name. And perhaps he couldn't go to the Supreme Court because he didn't write the best essay. As if I can recall Chandu Daftari, what he said after Keshavananda Bharati, that the boy who wrote the best essay got the first prize. So maybe that was the situation till 1984. Maybe that is the situation even continuing today. So there are persons who write something worth reading. There are persons who do something worth writing. There are persons who speak something worth listening. There are persons who leave a legacy worth celebrating and worth emulating. And we are remembering the legacy of Mr. Justice G.P. Singh, who was a lecturer first, then an advocate, and then a great judge who is quoted by the Supreme Court and by others, who is discussed in our classroom. So we are celebrating his legacy. Our thanks to his family, Justice Ajit Singh, former Chief Justice of Guwahati High Court, his son Ajay Singh and his family. So that was one point. The other point is about academia, that where are we on the global map of education? Be it QS ranking, be it any other ranking. If you go to the Mercer report or CII report of this year, um, around only 50% of graduates are employable. So what is happening? That's a serious question. And the emphasis was on questioning and critical thinking. I was discussing today with my students, and what I said, questioning is freedom. It's about free people. If I'm not questioning, perhaps I'm a slave. So that is very, very uh, defining point. And then um, there was last point that I noted, though, because we are getting late, that don't bulldoze the Constitution. Right. So with this, I thank you everyone present here, and thank you very much. Thank you, sir. Thank you, everyone.
Thank you, sir. With this, we come to the end of the Honorable Mr. Justice G.P. Singh Fourth Memorial Lecture. I now request everyone to kindly rise for National Anthem. Thank you, everyone. All the dignitaries are requested to join us for lunch at the guest house.